Our focus to some big breaking news that's coming in. This one in connection with the Sena versus Sena matter. The Supreme Court bench has assembled to pronounce the verdict on Uddhav Sena's plea, seeking larger bench. So no relief clearly for the Uddhav camp. In fact, what we're also picking up so far is that the bench is assembled and CJI Chandrachud is reading out as we speak in terms of this. If we were to talk about the background also being cited in this, Senior Advocate Sibyl Singhvi and Kamath for Uddhav Thackeray has demanded reference to a larger bench. On the other hand, we're also picking up is that Senior Advocate Salve, Mahesh Jetmalani and NK Kaul for Eknath Shinde has opposed the same. In fact, the latest that we're also picking up is that reference to a larger bench would have been determined together as per merits of case. So as we speak, these are the proceedings that are happening currently. So the breaking news that is coming in is that the Supreme Court has refused to re-examine the Nibam Rabia judgment. They will consider when they begin hearing on merits on February 21st is what we're picking up. In fact, remember, Uddhav had sought reference to a larger bench. My colleague Abhishek joins me live on the broadcast over the phone lines. Abhishek, good morning. Significant development coming in, but just break that down for us and give us more inputs as to about this breaking story in terms of the Sena versus Sena row.
Order. Firstly, it was something that was asked or wanted, requested by the Uddhav faction that a larger bench should be considered, a 7-judge constitutional bench or a 9-judge constitutional bench, to decide whether to reconsider the Nibam Rabia judgment. And it was specifically on the powers of Speaker, whether the Speaker against whom the no confidence motion has already moved, whether he is, eligible to take action or to disqualify the MLAs. So this is that for that specific thing.
Abhishek, I have to interject you at the moment, but I also have my colleague Harish joining me on the broadcast, of course, to get us the perspective about the legal sense as to where this stands. Harish, good morning. Significant development coming in. Can you break that down for us as to the fact that the Supreme Court has refused to re-examine the 2016 judgment?
Yes, that's right. As of now, there is no relief for the Uddhav Thackeray faction, which had sought the reference of the Nibam Rabia judgment, which is very core to this case, to a larger 7-judge bench. The 5-judge constitution bench led by Chief Justice D.Y. Chandrachud has said that we will consider this question when whether it needs to be referred to a larger bench when we begin hearing on merits on February 21st, that is coming Tuesday. Remember, Uddhav Thackeray had sought reference to a larger bench, and Nibam Rabia had dealt with Speaker's power to disqualify MLAs, and Shinde had benefited from the 2016 verdict. The judgment, in fact, deals with powers of the Assembly Speakers to deal with disqualification pleas. In the Nibam Rabia judgment, Supreme Court had held it was constitutionally impermissible for a Speaker to adjudicate on disqualification petitions under the 10th schedule. While a notice of resolution for his own removal was pending, the judgment had come to the rescue of 35 rebel MLAs led by Shinde, who is now the Maharashtra Chief Minister. The Thackeray faction had sought the disqualification even while a notice of the Shinde group for the removal of Maharashtra Assembly Deputy Speaker Narahari Sitaram Zirwal, a Thackeray loyalist, was pending before the House. Thackeray faction sought reconsideration of the Nibam Rabia decision by contending that, in fact, allowed defecting MLAs to stall disqualification proceedings against them by simply sending a notice seeking the Speaker's removal. But arguing for Shinde faction, senior advocates Harish Salve and NK Neeraj Kishan Kaul had said that there is no need for the reference, saying what happened was dissent and not defection. So anti-defection law will not come into play. They had said that anti-defection law is not a weapon for a leader who lost faith for his MLAs to hang on to power, cling on to power, and there is something called political morality to courts should stay away from all this. In fact, so as of now, there is no relief for the Thackeray faction, which had sought reference of this Nibam Rabia matter to a larger bench, because they had in fact found that the Eknath Shinde faction had benefited from this ruling, and so Chief Justice Chandrachud very clearly saying that this question will be considered when the matter comes up for hearing on merits on February 21st. So as of now, Supreme Court has refused to take a decision regarding referring Nibam Rabia judgment, which is very core, it is in fact core to this case, to a larger bench. Back to you.
Right, Harish. Thank you very much for getting us the latest on that. Like my colleague Harish also pointed out, it is, of course, a huge setback for the Uddhav Sena camp. We'll continue to track that particular story.